Thank you very much, Justice Ma, for that very informative presentation, and also your personal views on the issue of alternate dispute resolution, in particular mediation. Next up, our second speaker for this session would be Mr. Paul Hayes. Mr. Hayes is a barrister who has been admitted to practice in a number of international jurisdictions, amongst them Australia, England, Wales, and Fiji. Mr. Hayes currently has his legal offices in Melbourne, London, and Singapore, and is also an arbitrator registered with the Chartered Institute of Arbitrators in London. Mr. Hayes has a very rich and diverse experience in the field of sports law, having conducted matters involving sports law before the Court of Arbitration for Sport, the Sporting Disputes Resolution Panel in the United Kingdom, as well as in statutory and domestic tribunals, and court involving sports law issues such as doping cases, selection eligibility, on and off field conduct, results and outcomes, contractual disputes, sponsorship, competition organisation, and internal management and membership. Mr. Hayes has been involved in a number of well-known cases involving at the Court of Arbitration for Sports Appeals Division, amongst them the case of the World Anti-Doping Agency and the International Rugby Board against the Australian Rugby Union and Troy, which was a case involving doping and the issue of the time limit for the lodgement of an appeal under the anti-doping bylaws and the Court of Arbitration for Sports rules. He was also involved in the quite prominent case of the rugby case of Darcy against the Australian Olympic Committee Incorporated, which involved a misconduct charge and the issue of a proper exercise of discretion to expel a member from a team. Mr. Hayes has come all the way from down under to share his views with us on the topic of dispute resolution from the point of an international litigator. So please, let's welcome him with a big round of applause.
Thank you very much, Mr. Yip, for your most generous welcome, and thank you to Richard Weng for very generously inviting me to attend this second RWY Sports Law Conference here in Kuala Lumpur. And thank you for inviting me, and I must say it's an enormous privilege to be here. And I look forward to meeting many more of you throughout the day as the conference proceeds. My topic today is on sports arbitration in Malaysia, which is a relatively, compared to other parts of the world, a relatively new exercise or new activity. Certainly so far in terms of volume, there is an enormous amount of potential for this form of dispute resolution in this part of the world. And Malaysia is ideally placed to be the regional leader, and indeed, in my opinion, a force in the world of international sports arbitration. My lecture this morning will address three elements of Malaysian sports arbitration. Firstly, we'll briefly visit sports arbitration and sporting disputes, setting our platform for what is to follow in the form of new challenges in sports arbitration, in fact what is happening now. And then finally, after we've identified the new challenges in sports arbitration, we'll explore how those new challenges best be met, and particularly again with a regional focus. Rather than trouble you with the abbreviations, they'll be there for those to refer to in the hard copy of my paper. I'm not going to labour through each of those for you, but they're there for you to see. But I thought at the commencement of my address today, I should start with the quote from one of the world's most eminent sports law practitioners, that's Jan Paulsen, who was the head of international law at Freshfields based in Paris. And he quite rightly says, and it's worth touching on this because this picks up on everything every speaker has addressed this morning, from Chris to Justice Ma, and it's really why we're all here. For good or bad, few passions are as widely and as profoundly shared around the globe as the passion for sport. Its symbolism is often awesome. It brings out the noblest human qualities: good sportsmanship, the quest for excellence, a sense of community, and the basest, chicanery and mob violence. It is also big international business. Its capacity to motivate vast populations is nothing less than fabulous, and so naturally exercises a powerful attraction on those who would use it or use its magic for their own ends. And this is the important bit. The appetite for political influence and for money moves the heart inside the business suit with a force as primal as that of the dreams of glory that swell the distance runner's tunic. In a word, the realm of sport is that of their precious commodity. Therefore, it is coveted. It is also an internationally significant resource which can be squandered or debased. Therefore, the way it is controlled is not indifferent. And at the heart of that control is that of ultimate authority to establish norms and settle disputes. Jan Paulsen, as well as being a leading international lawyer, is also one of the more prominent panel members of the Court of Arbitration for Sport. So sports arbitration, well, what is it? Well, sports arbitration is the private adjudication of sporting disputes. Sports arbitration has principally been conducted by the Court of Arbitration for Sport, and it has its genesis in the law of contract. Essentially, the basis of all sporting disputes, the jurisdictional basis as to the means by which they are addressed, is contractual. In other words, we'll discover in a moment that the sporting contract, a private relationship between participant and organisation, is not only what governs the relationship between those parties when engaged in sporting activity, but also informs the nature in which any disputes which emerge as a consequence of that relationship are otherwise resolved. Now, CAS was set up in 1984. It is now 30 years old, and it is the premier international arbitration tribunal which determines sporting disputes. Certainly for Olympic sport, ultimately, the ultimate tribunal, all roads will lead to the Court of Arbitration for Sport. Any sport, whether it's Olympic or non-Olympic, which is subject to the World Anti-Doping Code, again, the final tribunal is the Court of Arbitration for Sport. There is, of course, some limited review of the CAS decisions under Article 190, subsection 2 of the Swiss Federal Code on Private International Law, but I shan't trouble you with any of those discrete propositions this morning, because that's really not the purpose as to why we're here today. But there is essentially what's along the lines of administrative or judicial review. The sporting contract, we've already addressed that, but we know that how it works in an umbrella setup. So in other words, the sporting contract is what defines the relationship between athlete and or participant and the sporting organisation. But what's critical in all of this is that there are 2 points to bear in mind. Not only is the immediate contract setting out the rights and obligations of the parties, but it's also worth bearing in mind that sporting contracts incorporate by reference the rules and regulations of their superior organisations, as we'll see in a moment. And those rules and regulations are then passed down through, if you like, an umbrella series of contracts which ultimately bind the participant or individual who is participating in the sporting endeavour. An important thing about sports contracts is not only is it consistent with common law jurisprudence, but also the specialised, the lex specialis or lex sportiva jurisprudence of the Court of Arbitration for Sport, is that sports rules, and these are the rules contained in contracts, must be clear and predictable and properly made and capable of understanding by athletes, so that the entire sport community are informed of the normative system in which they live, work and compete, and the circumstances in which these rules apply. So in other words, plain English is the gold standard as to what's required in sports contracts, so that the parties have a very clear understanding of their rights and obligations. We're not dealing with parties to contracts who are lawyered up as one might in a construction contract or anything like that. These are real people. And the Court of Arbitration for Sport, in many of these cases, be they doping cases or misconduct cases, while the evidence has the flavour of a common law or a criminal hearing, the actual submissions are an amalgam of not only that exciting common law or criminal type of evidence, but also revolve around commercial litigation type arguments as to the proper meaning of the subject clause which is alleged to have been breached, whether it's an anti-doping clause under the World Anti-Doping Code which has been imported into the sporting contract, whether it's a conduct clause as to how athletes conduct themselves on or off the field. Very often this egregious conduct, if you like, that's triggered a breach of the sporting contract will not only look at the rather juicy evidence that one might find in some of the more salivating types of cases that one might see in the criminal or common law jurisdictions, but also very dry argument as to how those facts fit in with the sporting contract and what those actual clauses mean, as one would find with the whisperers in the Chancery Division or the commercial and equity lists. So what we have here is, with the umbrella structure, is how we have the structure of international sport. At the top is the International Olympic Committee. To the right you see international federations, national federations, clubs, and then ultimately the athlete at the bottom. National Olympic Committee is also intervened, so here the Olympic Council in Malaysia is subject to the rules and regulations that it agrees to with the IOC, and again it binds its athletes at the bottom. So essentially the rules of the IOC come at the top, then the National Olympic Committees, international federations, national federations, local sporting clubs, they all pass down all of their rules and regulations to bind the athlete at the bottom of the tree. And not only is it the rules and regulations of doping and conduct, but most importantly is why we're here. It's also the dispute resolution clauses, the 1 minute to midnight clause that which people refer to in the context of commercial agreements, where nobody's really going to bargain or argue much over the arbitration clause or indeed the governing law clause. Well, there's no room to bargain on the part of the athlete. It is the way that it is. And ultimately, the athlete is bound to either their local domestic tribunal or in Olympic sports, and ultimately, or in doping matters, the Court of Arbitration for Sport. So what are sporting disputes? Well, sport, for a start, it's a highly organised social activity comprised of people playing games, in accordance, voluntarily that is, in accordance with an agreed set of rules, produce an outcome which results in the winner of a game. Sporting disputes is the discrete body of regulatory and case law which is unique to sport. So eligibility, for example, that talented swimmer who left Malaysia to move to Singapore on a wealthy swimming scholarship. They've been there 3 years, and yet suddenly that swimming sponsorship or scholarship has come to light, and the Malaysian swimmer has quite rightly decided to come home to Kuala Lumpur because while they were developed in Singapore, their heart is really in representing their country in Malaysia. Can they represent Malaysia under the FINA rules and under the IOC participation rules? That's what you call an eligibility type of dispute. Selection disputes, they're pretty obvious. Game rule disputes, for instance, what Justice Marr touched upon. Very hard to win on those cases, but generally the referee is always right. Doping, that will never go away, sadly. It's a constant in sporting disputes, and indeed by far and away in sporting disputes, along with football transfer cases, is the biggest category of work currently occupying the Court of Arbitration for Sport. On and off field conduct, we've dealt with that integrity, sports gaming and the like. So it's this discrete body of law, a jus laudorum, the law of games, a lex sportiva that had its genesis in the early 1980s, and all of that comes from the sporting contract. All of those types of cases are provisions which are agitated because they are in the sporting contract. What isn't sporting disputes? Well, those types of cases that really fall in two categories, contractual or tortious cases, people injured playing sport, if you like, and the types of associations cases that Justice Marr referred to, internal management types cases that are dealt with under the local administrative law, be it common law or at statute. So sports law spans private and public, domestic and international law. It's primarily international in character, given the dominant roles of the international organisations that pass that regulation down through the diagram of the umbrella to the athlete, and also the way in which those regulations are determined. Again, under the contract, it's all arbitration by the Court of Arbitration for Sport. I won't trouble you, given the time this morning, with the history of the Court of Arbitration for Sport, save here that in 1984 it was established, and in 2012 the Court of Arbitration for Sport established its regional office here in Kuala Lumpur, and it is now Kuala Lumpur and here at the KLRCA, which is the local regional centre for the Court of Arbitration for Sport for all disputes in this region, which is an enormous coup for Malaysia, and one has to once more applaud Professor Sandra Raju for being instrumental, along with the OCM, in bringing about that real coup for Malaysia. We've dealt with the CAS jurisdiction generally, being an arbitral panel. It's seated in Lausanne. It derives its jurisdiction from the sporting contract, but also from the Olympic Charter and the World Anti-Doping Code. And its awards are enforceable just like any other international commercial arbitral award under the New York Convention 1958. So, well worth remembering that because it is seated in Lausanne, different of course to where the arbitration is conducted, noting the difference between the lex arbitri and the lex loci, you've got to remember that even if you're doing these CAS arbitrations here in Malaysia, subject to the mandatory rules of the Malaysian Arbitration Act, once those have been dealt with, you're really doing a Swiss arbitration in Malaysia. And any ultimate review of this CAS arbitration is ultimately then reviewable in the Swiss Federal Tribunal because it is seated in Lausanne. The independence of CAS has been challenged unsuccessfully by many parties, given that ICAS, its governing body, has been set up to control its independence. And it's been a constant feature from the case of Gardner in 1984 all the way to most recently the tennis player Cañas in 2007. While there are more appeals from CAS decisions, primarily on the grounds of public policy, under the Swiss Federal Code for Private International Law, the challenges to independence have largely disappeared. The supervisory jurisdiction, I've also touched upon that, and the Swiss Federal Code of Private International Law. So, structure of CAS, two divisions: the ordinary procedure, which is essentially the trial division or first instance hearings, and the appellate division. In the appellate division, or even in the ordinary division, you can have one or three arbitrators who are appointed to hear the case from the panel of CAS arbitrators, of which there are over 200 worldwide. It is one of the more competitive arbitral appointments that you'll find amongst international arbitrators, trying to be appointed to the CAS panel, because while it might not be as lucrative as perhaps some of the more lucrative ICC arbitrations, it's certainly the most interesting. And if you look through a CAS panel as to who's on it, all of the big names in international arbitration are there, such as the gravitas of this institution and the interest in sports law in the cases it determines. Proceedings are conducted confidentially. However, unlike other arbitrations, CAS awards are public, and that's important because it comes back to the rule, what I call the rule of sports law, the determination of provisions under the World Anti-Doping Code and under the Olympic Charter. Come back to the actual wording of those clauses themselves so that the participants know, remember what was said in Quigley and also USOC. They know what the normative environment is in which they're competing, and it highlights the predictability that is required for those rules, because sport, given that it's a rules-based activity, means very little if people don't fully know and understand the rules by which they're competing. A very big difference between CAS and other commercial arbitration, even though it is a commercial arbitration beast where the awards are enforced under the New York Convention. Appeal hearings in CAS, whether you get there from a domestic tribunal or from CAS ordinary division, are de novo. Costs, again, discretionary, but the subject factors of each case are taken into account in dealing with CAS. So where are we now in 2014? Well,